Okay, so I found these and they don't really work. Well, one ear works, but I just thought I should wear them because they're funny. Okay, dear Honorable Judge Grove. So I published it September 1. I said Judge was so honest to admit he had not read his letter. I explained the main gist. I do pro se, but ask for help or consultation if needed. Okay. Once I saw the off ramp of the de escalating, I got the sign it was okay to brag on fam, to humanize me. Of course, I want to win on my merits and hard work and my integrity, not my family's big accomplishments. But yeah, it's kind of nice. Okay. Dear Honorable Judge Ted Grove, I would like to ask you to dismiss any current or future case or arraignment of my person on any interpretation of ORS 165.540 due to these limiting factors. There is no state interest in allowing felons to verbally abuse domestic violence victims who obtain Violence Against Women Act funded aid at the harbor or any other domestic abuse org. There's no state interest in contending that Oregon Revised Statute 165.540 one party consent does not apply to domestic violence victims seeking domestic violence advocacy for long ongoing gender based discrimination. In fact, according to the top 10 Google Scholar results for ORS 165.540, case State v. Lissy, the one party consent exception to ORS 165.540 telephone communications even includes one party consent of law enforcement listening in on a ransom hostage taking call. The theory that my participation in the speakerphone call must involve me interrupting the tirade or speaking more loudly than I do when I state he's making that up about the abuser's lies does not actually absolve me from one party consent rights. And it is not in the state's interest to allege that any such interpretation adheres. The case Veritas v. Schmidt details in the history of ORS 165.540, the one party consent exception was developed for law enforcement to have the broadest scope of for recorded calls. While much hullabaloo was made in deference to backdoor eavesdropping with FISA, what is that, Federal Intelligence Surveillance Act, court abuse on foreign contacts to or Foreign Intelligence Surveillance Act, on foreign contacts to gain eavesdropping on U.S. persons in contradiction to Fourth Amendment rights. Some people find total information awareness to be a refreshing work around total corruption. While any American person's particular opinion on NSA, National Security Agency, surveillance culture for national security may lend towards a certain paranoia of state agents, I assure the court in the state of Oregon that my concern over abuse of homeless women in Clatsop County arose from my personal commitment to humanitarian and feminist goals, not in any overeagerness to violate any constitutional right to privacy, even of persons engaged in unlawful discrimination or protection of violence against women. Indeed, my personal opinion on the national security implications of state surveillance is unsuitable for this court, but rest assured, I find it the highest honor to be wrongfully accused under a misinterpretation of 165.540 one party consent phone recording law. Well, it's true that in 2018, I was asked to wear a wire in the course of Officer Hansen's investigation of Chris Duffy regarding his sexual attack on me. It was unfortunate Hansen never followed up with the offer. As soon as I was able to comprehend what he meant, the answer was yes. I reminded Hansen of this during his interview. He thought perhaps his exact words were a pretext call, but they were, in fact, wear a wire. Indeed, the great tragedy of reporting sexual assault that was never prosecuted causes me great distress. And this case is a constant reminder of this and other violence I endured. With great deference to the difficulties law enforcement officers face in obtaining usable evidence around parameters of search and seizure law, I also want to inform the court that I studied with retired Los Angeles Police Department at Los Angeles City College 2 courses in law enforcement in 2009, including search and seizure surrounding issues of admissibility of evidence. This case is sadly subject to the fruit of the poisonous tree doctrine to such an extent that should the case go to trial, both the call might be withheld from the jury due to the district attorney's misinterpretation of 165.540, and then the place and nature of the call due to the prejudicial effects of the place and manner, such that 90% of the content should be concealed from the jury, making for an awkward kabuki dance of bad evidence, bad timing, bad location, etc. All the many limitations I might request for my due process would leave the case shrouded in mystery, and likewise, the Clatsop DA might also make such requests. While such a souffle of hot air might be fun, more realistically, with no hope of a public defender in sight, and with the grievous progressive injury my partner experiences and shortness of breath relating to his liver cirrhosis, perhaps hepatopulmonary syndrome, my attention really must be on my family. The case has been very destructive to his mental well being, and I've seen him in great agony facing 5 years of a terminal illness, severe bouts of hepatic encephalopathy, and a care gap, such that it is preferable to receive care from his family rather than a cold, sterile, assisted living facility. At the very least, should the state continue on with this meandering case, great attention to the needs of this medical predicament should be taken into consideration for scheduling and if there were any conviction or sentencing phase. Well, my contention that I should proceed pro se sounds like a lot of fun, as I was never happier than in paralegal school, nor or studying case law or academic studies relating to its analysis, particularly surrounding offenses to women. The delicate balance of my own health must be taken into consideration. As a pro se self representative, I believe I and Alexander Thomas could work towards some deal. In the interest of preserving evidence, I have not deleted the YouTube, but early prior to knowing the investigation, modified a short segment out to preserve the identity of the harbor representative, for which she thanked me. She assured me she did not want me to be prosecuted. I feel that she was victimized by the abuser's aggressive tone, and her professional life must be disrupted by a case in which an abusive man insists on abusing her client, whom she advocated for to the best of her ability. I believe it is in the state's interest to drop this case, even solely to protect the harbor from the emotional damage this case will cause, and find an alternative way to reflect on the advisability of inviting abusive males to shout at female clients, or find a way to buffer known abusers from having contact with their victims. It is the very concerning lack of transparency and scare tactics surrounding the lifeboat organization in question, showing a deliberate indifference to federal civil rights law, Americans with Disabilities Act, whistleblower protection law, and internationally recognized human rights principles that compelled me to capture abuse I knew to be of an ongoing and severe nature. It is a compelling state interest to ensure federal dollars keep flowing into the state of Oregon by ensuring adherence to such laws. Stomping down a whistleblower of failure to do due diligence in this regard is not equivalent to ensuring federal compliance. It would behoove the state of Oregon, as waged by the county of Clatsop, to establish nonprofit re- regulatory commissions or mechanisms and establish good faith attempts to ascertain the data necessary to see that grant funding is well situated in organizations fully compliant with federal laws. It is not a compelling state interest to silence whistleblowers of federal law violations or to do so in a way which violates Violence Against Women Act, Americans with Disabilities Act, etc. It is not in the state's interest to reduce the potency of Oregon Revised Statute 165.540's one party call recording exemption by trying to argue that I, a person both announced by the harbor advocate and present, and listening to the speakerphone call and initiating the call and present on the line to receive the verbal abuse, am not a participant, when it has been made known that I am present as a client of the domestic violence agency seeking representation and fulfillment of a clothing voucher. It is far more beneficial for the state to concede my participation in the call, despite the fact that I was in pain from a tooth extraction and flabbergasted at the rudeness of Ozark, Iraq, on the call. It would behoove the court to consider a motion in limine at future court dates, should this case not resolve promptly, as the very nature of this case is fraught with danger to my presumption of innocence and the stereotypes ensuing around women who experience domestic abuse or sexual violence. Indeed, the chief of police stated that due to Violence Against Women Act, likely the harbor likely would have little interest in breaching my privacy, and the district attorney little likelihood of punishing me with a prosecution. Any attempts to make the harbor uncomfortable or jeopardize the Violence Against Women Act funding would hurt this county immensely. There is additional burden of the fact of my low income and impoverished status also prejudicing the jury against me, due to presumption that my attempt to receive a clothing voucher fulfillment from a poverty related nonprofit may stigmatize me in the eyes of the jury. There is little to be gained from such a prosecution of me other than an enactment of a petty grievance on me for my eager attempts to report drug dealing, violence against women, or nonprofit misconduct. And then none of that satisfies compelling state interest. My suicidal intrusive thoughts are a long ongoing chronic condition for which I have federal disability protection. It is an unfortunate fact that disabled women face high levels of assault and abuse relating to their poverty and vulnerability. While my pro se status is considered, I would suggest a provisional granting of pro se status with an ultimate goal to have legal counsel, at least in some consultative capacity, should this case not be resolved. And furthermore, if I felt the pressure of pro se status was so intense that my mental health deteriorates, I would let the court know so that expedited counsel could be arranged. In the course of seeking counsel, I've spoken to Mary Merck, her assistant, James von Bookman, Clark Fry, Ashley Flukinger, Paul Hood over text, who says he'll try to find me lawyers. Matthew Ellis's office, Kim Sordeal over the phone, Kevin Solly via email, John DiLorenzo, ADA lawyer, and I've sought counsel from the Oregon Law Center, Crime Victims' Rights Center, the ACLU, the EF, the Electronic Frontier Foundation, and even Project Veritas, because hey, why not? While all of my attempts to gain counsel have been fruitless, the question arises in my mind why the county of Clatsop doesn't spend its efforts encouraging people like me to go to law school rather than damaging our records so we feel defeated and humiliated at our uneducated guesses. I never in a million years would have suspected there was anything criminal in my one party consent recording, and finding me in this scenario has renewed my interest in innocence and criminal defense. My dear mentor in Los Angeles, Stephen Schwartz, allowed me to sit in on his framing of defense case materials for a not guilty by reason of insanity case he was working on, in which a man killed a convenience store clerk with a baseball bat, but was not guilty by reason of insanity. It was Steve's opinion that crimes only occur in states of insanity. It is also not in the interest of the Clatsop District Attorney, acting as the custodian of the state of Oregon's interest, to retaliate against me for making Bureau of Labor and Industries complaint of disability and gender discrimination regarding lifeboat, other than by shielding the county of Clatsop for grant allocations to an organization alleged to have violated the civil rights of its clients. If this conflict of interest underlies this case, oh dear, what a can of worms. While it is true that the Bureau of Labor and Industries investigator of the lifeboat case also investigated Multnomah District Attorney Michael Schmidt for gender discrimination, there is no reason the Clatsop District Attorney should get involved in any bully case unless there are incorrect practices therein, and it seems to be an overextension of the power vested in it to exceed any principle of interference. Well, even if the district attorney and I have differing opinions of the 165-540 one party consent application, prosecutorial discretion could concede that there is little to gain from proceeding with this case, and much better would attention be focused at the crime and violence associated with the district. The complexity of the pending Boley case may result in further investigations of misconduct, and the state has no interest in deterring participation from other potential witnesses by prosecuting the chief witness, acting as a sort of class representative, if you will. I understand the wiretap law arose in a time of great paranoia during the Red Scare in 1955, and with succeeding modifications and proposed modifications during a time when technology did not have the amount of technical variations as is common now. I would like to thank the courts for entertaining the prospect of hearing this case, and thank you for listening to my observations, and request a complete dismissal of all charges and a letter of reference should I ever get around to going to law school. I would like to let you know that I have increased my counseling with the assistance of Crime Victims Compensation, and I'm continuing to communicate with the Astoria Police Department about a case I began reporting 1 year ago about gender-based violence. I recently found out the APD did not even refer it to the DA for prosecution, possibly due to mishaps regarding an officer's relocation to Michigan. It must be remembered that consent is the basis of policing, and the consent of the public involves a great amount of trust, and when that trust is abused, the public confidence wanes. I assure the courts my personal philosophy of nonviolence is an inherent factor in my life. My mother's work as a nurse greatly influenced me. She worked with veterans, the blind, many categories of care, including intensive care unit, and notably emergency room care and psychiatric care at the Veterans Administration. My father, on federal letter of reference from his father's people, got employment in social services in the 1960s and 1970s, working on the war on poverty, helping low-income women with resumes and social advancement. My father instilled in me great respect of women's professional achievement and was greatly influenced by pacifists and Quaker philosophy of social responsibility and waging peace. My grandmother taught English to non-English speaking embassy wives in Washington, D.C., and at times faced threatening phone calls of an alarming nature due to her husband's employment. In one such incident, the call was so disturbing, an entire write-up was waged as a Freedom of Information Act letter revealed. Her mother wrote society news for the San Diego Union. My other grandmother, known as the Scourge of Scappoose, was known for her radio talk show and her opinions at the school board meetings. She wrote her own home-published newsletter. She wrote the Vietnam draft board to back off her boys, or she would shoot off their feet herself to maim them rather than send them to an illegal foreign war to be surely killed. Grandfather was an independently self-educated mining engineer working in the steel mines with a true Finnish sense of sisu, courage and stony cold silence about almost everything except things he designated horseshit. The other grandfather, also born May 2, 1909, was Norwegian and suffered the loss of his mother due to her death in childbirth of his twin brothers. He was in the Navy, OSS, and later CIA stationed in London in 1956-7. I'm reminded of this greatest generation. We did not win World War II by cowardice. Father had summer CIA gigs as a teenager, but was too creative for long-term desk work. He gravitated to music, poetry, fantasy, horror, biography, screenwriting, literary theory, and book collecting. Devastated by the war in Vietnam, he raised me with intergenerational trauma about his family's line of work, and I believe the call of duty is in my blood, not in my resume. Some of my uncles and cousins have a footprint in Mexico where they practice ministry and humanitarian aid and music. One of my cousins, while struggling with alcohol, is an internationally celebrated Navy SEAL and Fox News contributor and pundit. While all of my siblings have remained childless by choice, a sudden chance emerged. I will become an aunt this Christmas. My family I consider to be the homeless, and I highly encourage you to listen to them and create a culture of listening to them to meet their needs. If there is a mistake to admit I lacked courage and coalition when I needed it to fight for a better way forward for the poor in this county. There are no unredeemable people, and the people working towards poverty relief should work as allies. It would possibly please the district attorney that this case has pushed me to my knees, saying many Hail Marys for all parties and the DA himself, as my Catholic upbringing was strict and harsh. My educational achievements include scholarship at all-girls Catholic high school and college, at which I studied philosophy, art history, literature, and anything that suited me with wild abandon. I worked in caregiving and fundraising for nonprofits. My father's influence on me cannot be overstated, as his nonviolence meant I was never spanked or mistreated even once by him. And I have a great respect for gentlemen and a great dislike of ruffianism and poor manners. I admit for the court my overeagerness to share the pain of the discrimination and violence against women in the homeless community led to this case. As it stands, I know of multiple sexual assaults that have gone unreported due to complicated factors, including loss of confidence in the justice system. A complete overhaul of policing and prosecutions would assist victims feel safe to come forward, and I firmly believe female survivors are more inclined to open up to female investigators, and this must become a priority in this county. My observations aside, I will spare you the long version for now, Eng. And he was such a sweet man. He was lovely. Ted Grove. I had to research about him before I could write that letter. He's from St. Helens, and it was a really sad St. Helens story. Is that the police chief was killed by a young guy, and he sat on some of that. And then also having family in Scappoose and St. Helens helped me kind of orient there's a culture there. And it's sort of that they're like somewhat rural people, but they're somewhat city people because they're close enough to get to Portland if they need to, but they're kind of out in this pretty section, quite a long drive. So I felt really happy to speak before him. I mean, given that the whole thing made me really sick, but and like I don't think anyone read that. He didn't read it. He didn't have time. He had like whatever 12 other cases that day. I don't think I know for sure that the prosecutor didn't read it because he wasn't informed of what I was informing him when I spoke with him thereafter. But anyway, wasn't that sweet? And they left that off, and I don't know why. I feel like, anyway, what should I do with these? This is the one that works. Maybe I could try the fix, squeak them around a little. I want to keep reading. There's something else I want to read. Maybe one day I can read the whole 500-page scan. That day's not today. There's a funny one where I relate when Ron Brown, the district attorney, was shouting on the phone at me. It was like really funny.